Welcome to the Arete Podcast, the podcast created to help senior executives and the organisations they lead live up to their full potential. Join us for cutting-edge interviews with leading senior executive and board members across all industry sectors, and for practical tips to accelerate your executive career. And now, here's your host, Richard Triggs.
I've been really excited about having you on. You and I caught up at a presentation you did for a CEO group that I'm part of, and I found what you had to say really fascinating, and I thought that our audience would probably be very interested as well. So good to have you here, and how's your week started, given that it's lunchtime on a Monday?
Yeah, thanks, Richard. Thanks for having me. Very excited to be here, and it was great chatting to your group a couple of months ago. I recall you had some great questions, which is always my preference to engage in those chats when someone's really quizzing you on what you're talking about. So yeah, it was a great chat. This week, it's cold, as you and I were just discussing, but it's good. I'm getting back up to speed after being overseas for a little while, so plenty to do, but it's looking good. We've got a few things that are starting to look like good opportunities, so it's an exciting time for us at the moment.
Excellent. Oh, well, that's great. So tell us a little bit, firstly, Vincent, about your current responsibilities. I know you're a director of your own business, Sajen Legal. So tell us a little bit about that.
Yeah, that's right. So I'm one of two directors. My business partner, his name's Tim Borum. He's based down in our Sydney office. I'm up here in Queensland. So we've got a Sunshine Coast office and also a Brisbane office as well. So Sajen Legal, we operate in two main areas. I manage the commercial litigation team, and Tim manages the business and corporate team. So commercial litigation, for listeners that might not be aware, it's really means disputes that relate to business, assets, property, things like that. So if you're in court in relation to some form of dispute, it's not a family law dispute, it's not criminal, it's not personal injury. Most other things that relate to business assets, money, that falls within what we do. We also do a lot of work in the insolvency area. So what that means is sometimes we act for insolvency practitioners, so that's liquidators or bankruptcy trustees. Often we act against them, so we're acting for, it might be a director of a company that might have failed, or an individual that's otherwise associated with a business that hasn't gone well, to protect their interests. So that gives us a bit of a unique experience, which ties in well with our asset protection and structuring as well. So we make sure that when our clients are setting up business or going into a new relationship, we make sure things are set up so that if things don't go as planned, their nest egg is protected.
Right. And I note from looking at your LinkedIn profile that you were a fairly recent graduate before you started your own business. So what led to that, and why the move into this particular area of law?
Yeah, it's a good question. Like many lawyers, I fell into it a little bit. Most young lawyers who I might be interviewing for a new job, when they tell me what kind of area of law they want to do, I roll my eyes a little bit, because the truth is no one knows until you get in there and start doing it. So I started out 2013, I think, in my first law job. Started off doing property law, which developed into property development type area, and then moved into a bit more of a commercial role, so business, sales, purchases, leasing, things like that. And then an opportunity came up to join the litigation team. That would have been about 2017, and that was something I was always attracted to, so took up that opportunity, and I've been doing that ever since. So it works quite well, because I've seen it from both ends of the spectrum. So there's the front end where you're doing the deals and drafting agreements, and then there's the back end where the wheels are falling off a little bit, and you've got to work out what the parties' rights and obligations under those agreements are once a dispute arises. So in terms of Sajen Legal and how I got into that, I've been with the firm now for, must be getting close to 10 years. Relatively early on in my career, I guess, I came on as a director. The previous managing director, he decided that he'd had enough and wanted to try something new. He founded the firm 25 years ago or so. So at that point, I decided to step up and take over from there. That was maybe 2-3 years ago. Now it's just me and Tim, my existing business partner.
Okay, great. And does Sajen as a name have a bit of a story behind it?
I should know this better. It's apparently it's got something to do with eternal life or eternity or something like that. But that was before my time, so I wasn't
Right.
involved in the naming. But I ought to learn that better.
And do you know what, is it from a particular language, or, is the former, managing director, from a, different ethnic origin, or?
No, he's not. All I know is there was a consultant that was involved that came up with that name quite some time ago. Must have been 20
Right.
years ago now. So no, I don't know too much about it. I inherited it, and we've stuck with it.
Oh, fair enough. Yeah, there's a funny story. There's an executive search firm in Australia called Boomerang, and the guys who own that, I know pretty well. And anyway, they decided that they wanted to be broader than just Australia, so they went, okay, we'll hire this marketing company to assist us, and we want Boomerang's a bit too Aussie. We want something that's a bit less Aussie, and so they came up with, well, why don't you cut the BO off the front and the NG off the end, and now you're O'Meara. And so went from Boomerang to O'Meara. So, these company names come from all kinds of interesting, backgrounds, but I'd be interested to learn a bit more about that. Okay, cool. So, obviously the world has really changed in terms of post-COVID and, the changing dynamics about business across, virtually all facets. But from your perspective, from a legal perspective, what are some of these trends that are happening that you think that business owners and CEOs should be paying attention to?
Yeah, so look, our mission statement is that we help business owners navigate legal challenges with confidence so they can protect what they've built and focus on growing their business. So what we're seeing in recent years, we're still in the post-COVID economy, there's increased pressure on businesses. So that mainly takes the form of what the ATO is doing. You can jump on the ASIC website, and it's all public information. You can look up the rate of company failures from month to month. And what happened when COVID hit is basically the government put the brakes on insolvencies. So they pulled everyone away from that area completely to allow essentially the economy to survive through that period. So now what's happening is over the last few years, they've been easing back into, I guess, the normal position. And the ATO, as part of that, is really starting to ramp up the pressure that they're putting on anyone who's not complying with their tax obligations. Mm-hmm. So the ATO by far is responsible for the most corporate and personal insolvencies. They really perform the function of winding up these businesses, because it's often the case that tax is the first debt that doesn't get paid. And the ATO is well enough funded that it can go through and wind up all these companies that don't pay. So that's mixed in with interest rates are still high. So that's creating pressure as well. There's a lot of businesses that really perhaps might not have survived in ordinary trading times, but because of this relaxation during the COVID period, they've limped on. So now that's really starting to flow through, and businesses are facing more pressure. So that creates a few risks for businesses. Even if your business might be very successful, you're doing everything right, you're paying your tax debt, all the rest, there's a good chance that someone else that you deal with in your industry is likely to suffer these consequences, and that might have a flow-on effect for you. So, for example, it might be a key supplier, a key customer, or some other business partner might fail, and that could impact your business in a number of ways. So that's the first thing that we're seeing. Now, how that flows through is lots of disputes about non-compliance with contracts. So mainly not paying debts when they're becoming due, which obviously creates cash flow pressures of business. The other big one that we've been seeing, and this really has kicked off right when COVID hit us, was disputes within companies and business structures. So we're seeing lots and lots of shareholder disputes. It's hard to put a finger on what's caused that. My best guess is that when COVID happened, there was a lot of stimulus coming in to the economy, and probably people jumped into bed together with each other with new and exciting businesses, and it's not quite working out. So lots of shareholder disputes when it probably flows on from tougher economic conditions, and when things aren't going quite as well, there starts to be some tension between the parties. So those are the two main areas I would say. So non-compliance with contracts and internal disputes within structures.
Okay, great. Well, let's talk about those each individually. So let's say that my business is doing well. I'm paying my tax. I have no issues in relation to that. But one of my key suppliers, unbeknownst to me, is dealing with some issues. How do I tackle that? How do I mitigate that risk? If I don't have an awareness of the situation, what can I do about it?
Well, the first thing that you should do is make sure you have your contract terms squared away. So this is one of the biggest problems that we see with new clients that might come to us. Exactly as you've just explained, it might be a key supplier has gone under. They might have already paid for whatever it might be, building materials or whatever product they might be buying, and then suddenly there's been a liquidator appointed to this supplier, and they say, well, what do we do? Now, 90% of these disputes or issues could be resolved if that business or individual had just had proper contract terms in place. It's shocking how common it is that businesses are operating successfully based on terms and conditions that maybe they got from Google. ChatGPT is a big one. People trying to write their own terms and conditions from ChatGPT, which, look, AI is great, but it isn't yet at the point where it can replace a lawyer on those things. So that's the first one, making sure that you have the right contracts in place so that if something happens, as you say, one of your suppliers or customer goes under, you're in the best possible position to protect your interests. So that's the first thing I'd say. The second thing I would say is, great, you've got this contract that's been drafted by your lawyers and it gives you all the rights that you might need. But the second important thing is making sure that you actually administer that contract in a way that preserves those rights. So what I mean by that is you don't just get a contract, put it in your chop drawer and never look at it, but you're actually aware of how it operates and you actually follow what's required under the contract to make sure if things do go bad, then your interests are properly protected. The other big one that I would say is at least being aware of what options you might have in terms of securing your rights. So what I mean by that is if you're owed money or if there's some obligation that a third party might owe to you that isn't being performed, making sure you're aware of what options you have in terms of having rights over the assets of that other entity. So the simple scenario is where a customer might not be paying you money that's owed, having rights to either recover products that you might have supplied to that customer or alternatively have recourse to any other assets that they might own. That might include land, particularly if it's guarantors are liable also, or it might include all sorts of commercial property, so vehicles, stock, all sorts of things. So there's some relatively straightforward contractual terms that parties can include in their terms, which will give very powerful rights over those assets. And if say a customer goes under, a creditor who's got those security rights is much, much more likely to get paid. So again, one, having the contracts in place that give you those rights over the assets, and two, actually administering the contract by taking steps to ensure that those interests are recorded and properly preserved.
Mm-hmm. And so would this be a case where companies would be looking to draft up unique agreements for particular key customers or suppliers, or typically are you suggesting that a company would preempt by having a sort of a fairly generic document that might be, drafted by a company like yourselves that they would then use for all of those arrangements?
Yeah, look, it depends on the industry and what the specific client is dealing with. In most cases, you'll have your standard terms of trade, which will have all sorts of protections in there. And you get that done once. You should review it fairly regularly. That's another issue that we see from time to time. Someone pulls out their terms and conditions. It was drafted by a lawyer, great, but it was done 10 years ago and all the legislation that applied at that time may have been repealed. But generally speaking, having a terms and conditions that can be used for each deal or sale is usually sufficient. But for some industries, it might be that you're getting bespoke terms prepared for each arrangement. Really depends on what we're dealing with. Obviously, there's going to be increased cost for the bespoke option. But look, it's a great starting point if you've got your general terms and conditions that you can ensure apply to your contracts when you're doing business.
Right. Okay. So obviously we're talking about one way that businesses can mitigate risk, but what are some of the other ways that businesses that you're dealing with can, some of the steps that they can take to avoid any potential future legal challenges and disputes?
Yeah, so what I've just mentioned is probably the main thing in terms of protecting the interest before a dispute arises. The other thing I should mention is doing your due diligence. It's not uncommon at all that that a dispute arises and we get a contract come in. The contract looks good, but they've entered into it with the wrong parties, or they've there's a guarantor that should have been bound but hasn't signed properly. So making sure that you've got the parties right in the contract, and also if you are taking security over assets, doing some searches and finding out what they actually own so you can determine whether those securities are actually worth the paper they're written on. So that's before a dispute arises. If someone finds themselves in a dispute, yeah, there's a number of things that they can do to make sure that their interests are protected. The first thing, the biggest, I guess, advice that I've got is being aware of evidence that might be used for you and against you in the event of a dispute. So it's not uncommon that a dispute might arise and the parties try and work it out between themselves before going to see the lawyers. And they might send an email or a series of emails which they think is protecting their interests or somehow serving their interests, but it's catastrophic in terms of what their actual legal position is. So number one tip is don't send emotional emails. Always think about what you're doing and ideally get legal advice. My general rule is dance like no one's watching, email like it'll be read out loud by a judge in court one day, because sooner or later it will, and it's generally a good policy to have. Some other tips in terms of evidence, I always say to clients, assume you're being recorded. It differs state to state, but in some states in Australia, it is legal to secretly record conversations, provided that you're a party to that conversation. So what that means, Richard, if you and I are having a meeting and I want to try and get some evidence against you, I could have a tape recorder in my pocket and encourage you to say things that might, make you look like the bad guy in terms of a dispute, and that might be able to be relied on as evidence. So again, it's a good general rule to assume you're always being recorded. One day you'll probably be right, or maybe at least. And the flip side of that is consider whether you should be recording. When it comes to a dispute that ends up in court, evidence from witnesses as to what occurred, he said, she said type evidence is admissible, but it's nowhere near as powerful as a recording or a written document. So if you think that someone else is going to potentially say something that might assist your interests, then consider whether that should be recorded. A few other general tips is being aware of the power of other parties to obtain documents in the event that a dispute arises. There's two main categories there. The first is that if there's a legal proceeding on foot, so Richard, you and I are suing each other over some contractual dispute, generally there's an obligation of what's called disclosure. What that means is the parties have to hand over all documents that are directly relevant to the matters that we're in dispute over. So emails to accountants, emails to business partners, things like that. It could be all fair game and you have to hand it over to the other side, and they could use that as evidence against you. The other broad category is in the event that a company or an individual becomes insolvent, so you get a liquidator appointed or a bankruptcy trustee appointed, they've got very broad powers to get documents. Basically, they can write to relevant parties and just require them to hand up documents that might assist in a liquidator bringing claims. And they can also drag relevant witnesses into court, put them in the witness stand and force them to answer questions. So some general tips. Again, be very careful what you put in writing. Be aware that Lawyers, so if you're my client, Richard, any communications that we exchange are protected by legal and professional privilege. That means is it's confidential and no one can compel either you or I to disclose that communication to anyone else. That's a very important privilege, but it only applies to lawyers. It doesn't apply to accountants, and it's very common if someone's in a dispute or something's going wrong, the first person they get in touch with is the accountant. They'll send emails thinking that it's confidential. A liquidator might be appointed later, or in some other dispute, the other party can get their hands on those emails and they can be a very big problem. So general tip is, if you're not sure, check with your lawyer, or if you have to speak to your accountant or someone else about things that you wouldn't want someone else to see, pick up the phone. It's conversations are forgotten, emails aren't. So it's just good to keep those things in mind.
Okay, so it sounds as though, when dispute is looming, probably one of the first things that, particularly if it's a substantive dispute, is that the business owner or CEO needs to talk to the lawyer as the first port of call rather than, later down the process. What are some of the other things that should be immediately addressed and taken into consideration?
The failing to respond to, I guess, allegations that are being made. So often what happens is, say, let's talk about shareholder disputes specifically. Often what will happen is it turns into a bit of a game of parties trying to build a narrative against the other. So they'll start sending emails that makes them look like the good guy, and they'll try and bait the other parties to do something to support that narrative. Whether they're trying to bait the other side to come back with with an emotional email or even just to ignore that. So I guess what I'm getting at is, if someone's making allegations that aren't true, you might just think, oh, that's crap, I'm not going to respond to that. But you need to be careful that in failing to respond, that isn't somehow inferred against you, that it might be true or that you're hiding something or whatever else. So yeah, look, the big one is, whenever you get any feeling that a dispute might be on the horizon, talk to a litigation lawyer and start talking about a strategy, because the law is only one part of this. A huge part of any commercial dispute is having the right strategy to making sure that your interests are protected from the outset.
Okay. Speaking a little bit more broadly than just disputes which could potentially end in a litigation event, what do you think are some of the more common mistakes from a legal perspective that business owners and executives make? What should we be more cognizant of?
The biggest one is waiting until it's too late. So thinking that someone who's not, say, complying with their obligations under a contract, but they're promising that they'll make payment or do whatever they promised to do if you just give them more time, and waiting too long until that any recourse that you might have had is lost. So I'll give an example. So you might have a contract that says, your customer obtains goods on credit, they might owe you $1 million in connection with that contract. You might have a guarantee from the director of that customer, which gives you rights in respect of the assets of the guarantor. Now, that might include a right to lodge a caveat over their property. Caveat basically just freezes title and prevents an owner from selling or refinancing the property. Many times we've had clients that have come to us that have got the proper clauses in the contract. They've got these what are called caveatable interests, and we quickly lodge a caveat over that guarantor's property, even though they're part of the customer saying, don't worry, I'll pay. But in the background, what they're trying to do is they're trying to sell their property, or maybe they're trying to refinance their property to protect their own interests. But once we've got that caveat on there, we can get between that, and basically we become the most important person in their life and they have to pay us. So that's the happy story. The unhappy story is the client maybe waited a week too long to give us a call, and it turns out that the guarantor sold their property last week, and that caveatable interest is now worthless because the property's gone. Right. Another similar example is PPSR charges. So that's basically registering securities that you might have over a customer or a guarantor's assets other than land, and missed the strict timeframes for lodging those interests on the PPSR. And if you miss those, you've just got no rights at all. So waiting too long is a probably the most common mistake. As I mentioned earlier, failing to do your due diligence, make sure you know who you're actually contracting with and what assets they might have if you might be concerned about whether they're going to pay you. But the biggest issue is just not being aware of these things. So it's, most, it might not always be the case that if you've got these rights to lodge caveats or PPSR charges, you might not go and do that because you want to keep on good terms with the customer or for whatever good reason. But I always say it's nice to have the big stick, even if you never swing it. So I would say the key thing is get some advice and at least be aware of what your options are. Then you can make a commercial decision as to whether you exercise them on or not. Don't find out once it's already too late.
Yeah, look, I certainly, one of my own experiences has been, for example, dealing with ASX 100 level, organizations. And as a small supplier, you kind of feel obliged that you need to accept and contractually agree to whatever they propose. And a more recent example for me was you're being invited to join a PSA and the client saying, look, we'll pay you 62 days after month end that you invoice. And most organisations would just go, well, if I want to be on their PSA, I have to agree to those terms. Whereas, I turned around and said, oh, look, I'm not prepared to accept that. And they said, okay, we'll pay you in 30 days then.
Yeah, don't ask, don't get. Yeah, that's right.
And then they said, oh, and if you want to be a preferred supplier of ours, you need to give us your full financials for the previous 3 years. And I said, why? Give me one justifiable reason as to why I should supply that to you. And they said, look, we don't have to justify it. You need to, provide those or you won't be on the PSA. And I said, well, I'm not going to provide those. And they said, okay, no worries. We'll put you on the PSA anyway. So it's interesting. I think, people might listen to this and go, oh, this sounds so onerous and I'm so not desperate for the work, but I don't want to potentially piss off my my potential customer by putting all these onerous expectations on them. But, far better to have, as you say, not necessarily the big stick, but, the protection rather than feel you need to just adhere to whatever they want to put forward to you. Otherwise, they're the ones holding the power the whole time.
Yeah, that's right. And look, no doubt, you're going to deal, or some people will be dealing with players in the industry that have the power to just say, either you take it or leave it, or if you don't, we'll get the next guy, instead of you. For sure, that will happen sometimes in the building construction industry in particular. You're dealing with these big guys that have all that commercial power. But the important thing is you're in a position to make a commercial decision at that point, rather than just going in, not really knowing, what your rights and obligations are. And as you said, don't assume that someone won't amend their terms. It's quite uncommon that you ask for an amendment and they say no, and now we're not doing business with you at all. 99% of the time they'll come back and say, no, this is our position. And then you decide whether you want to keep pushing on that or whether you're willing to take the risk. But yeah, as I said, don't ask, don't get. You should always at least consider whether you should be looking to amend the terms to properly protect you.
Yeah, I think also it's the fact that, procurement in these organisations have to justify their own existence. So often procurement will put a bunch of hurdles in that aren't necessarily commercially sensible. And so it's always useful to ask the question. The other thing, Vincent, we've been talking a lot about today is, between an organisation and its suppliers or customers. But what about internally in terms of these arrangements with employees? Obviously, as a recruiter, I'm often asked to talk to organisations about particular issues from an employment perspective. Is that an area of the law that you get into as well?
Yeah, it is. My business partner, Tim, he deals with most of the front end side of the employment work, so drafting agreements and things like that. But if it turns into a dispute, then yeah, it will come within the scope of my team. So probably the biggest issues when it comes to employment contracts from my perspective is, one, intellectual property. So who actually owns or who's got rights in respect of the goods or services. And two, restraints of trade is obviously a hot topic as well. With the first issue, it's very, very important that the contract clearly outlines, exactly, if I'm acting for the employer, that they've got all rights in respect of anything that the employee is doing while they're getting paid, to avoid any confusion over that issue down the track. Restraints of trade, keep an eye on that one. The Labor government were talking about abolishing restraints of trade completely, with some exceptions for high income employees. Look, restraints of trade are notoriously difficult to enforce anyway. You and I have talked about this a little bit. The starting position is that the courts don't like them, and they're deemed to be void unless the employer can show that they're reasonable in all of the circumstances. So I won't go into too much detail there, but the takeaway point is it's better to have the clauses in your contract and have an argument over it, or compared to not having them at all. Because if you don't have them in there, the employee is free to go and work for your competitors and clients. So always important to have them, and it is really important that they're drafted by a lawyer, because if, as I said, a court will have to determine whether restraints are reasonable. So that requires a very fine balance between making sure your rights as the employer are protected sufficiently, but not stepping across the line that would deem those restraints to be unreasonable, in which case they may be completely unenforceable and throw them in the bin.
Yeah. And I think, to go back to one of your earlier points, important to have those employment contracts regularly reviewed and updated. I mean, certainly my business, now 16 years old, we've been working with an IR lawyer for most of that time, and I'd say at least every 2 years, I have her review and amend those, because situations changes, and you have to make sure that you're in front of whatever new changes are happening, as you just spoke to in relation to restraint of trade. So for business owners and CEOs listening to this podcast, who go, I mean, one of the reasons I had you on, Vincent, is because when you gave your presentation, I was like, holy crap, there's a lot of things here that I don't even really think about, and I probably need to start thinking about them. And so, what for people who are listening to this, what's that one critical piece of legal advice that you really hope that they take away and invest some time into learning more about?
The main lesson would be that the legal system that we've got in Australia isn't designed to guarantee justice, or that a common sense outcome will prevail. So many business owners operate under the assumption that a court will ultimately make a decision based on what's fair. And we have lots of conversations with clients who are in a dispute, that this isn't fair, this isn't fair. I usually say leave fair at the door, because that's unfortunately not how decisions are made. Courts make decisions based on evidence, procedure, and the strength of your legal position, and the available evidence is a huge part of that. So it's important for businesses or executives to take proactive steps to make sure that their legal position is protected. You can't rely on the system to sort things out later. You need to secure your rights, your documents, your arrangements, and act early to make sure your rights are protected. So that's probably the theme of what we've been talking about. Act quickly, pick up your phone to your lawyer and just make sure everything is squared away. Prevention is much better than a cure.
Okay, excellent. Well, look, certainly for people who are listening to the podcast who think they'd like to learn more about what Vincent does and potentially engage with you, then we'll have in the show notes links to your website and your LinkedIn profile and so on. But I suppose, Vincent, before we wrap it up today, getting back to a bit more about you, we've talked a bit about, law and so on, but I mean, having made that decision to go out and now be doing your own show at a relatively young age, are you loving it? Are there things that you in hindsight you might have done differently? What are you excited about for the future?
Yeah, am I loving it? Probably like a lot of your listeners. It depends what day of the week you ask me, maybe even what hour of the day you ask me. Yeah, look, I am. We had a bit of an opportunity when I was first coming into the business to get swallowed up by a big company that was looking at going public. So that was a big decision at the time. There was potential big upsides, but ultimately I made a decision not to go ahead with that because I wanted to be the master of my own universe and not be accountable to the big corporate side of things. So look, it's been great. I've very much loved it, but like everyone, there's good days and there's bad days, and there's challenges. It's certainly never boring, but I always say I'd rather be stressed than bored. Yeah, that's certainly the case. So yeah, it's good. It's, as I said, it's exciting. We're looking to grow, both in terms of our number of staff, geographical location, client base. So yeah, we're starting to get a bit of momentum, and it's very exciting at the moment.
Oh, that's excellent. And on a personal level, you're looking forward to the family growing.
That's right. Yeah, first one on the way, little girl, which it's a couple of months away, so that's creeping up very quickly. So yeah, that's going to be a bit of a shake-up of things, but plenty of people have done it before me, so I'm hoping I'll be able to work it out.
Oh, that's excellent. Well, look, Vincent, I really appreciate your time today, and great chat. And for anybody who's listening, certainly I'd strongly recommend that you reach out to Vincent if you think he can assist you. And other than that, have a fantastic afternoon, and I wish you all the success with your business.
Thanks, Richard. Great chatting, and thanks very much for having me. Talk soon.
Okay. All right.
Thank you for listening to the Arete Podcast with Richard Triggs. We frequently feature guests from organisations we are currently recruiting to build the company brand as an attraction strategy for candidates. If you would like to promote your organisation's brand as an employer of choice, please contact Richard directly on 0403 588 517 or via email richardt@areteexecutive.com.au.